Municipal councils are expected to act in good faith and in the public interest when creating bylaws. And they also are expected to act in good faith when carrying out the responsibilities established in the bylaws. And good faith essentially means acting without any improper purpose. Bylaws should also be clear, enforceable, and accomplish the desired goal of council. Council should only pass standards in bylaws that they are willing to enforce, and the public interest must be at the heart of all decisions made. The principle that council can only act through bylaw or resolution really can't be stated enough, and it is specifically outlined in sections 109 and 123 of the MGA. The MGA mandates that municipal councils pass a number of mandatory bylaws. These include election bylaws, access to information and protection of personal information, code of conduct for council members, procedural bylaws, emergency management, and land use planning bylaws. And note the dates for those last two bylaws have been extended to 2021 for emergency management and 2023 for land use planning. The MGA includes several different provisions that provide council with discretion to enact bylaws in various areas. So an example would be section 161 around tourism accommodation levies, local improvements, section 202, and shared services. Council must do bylaw enforcement through an enactment of a enforcement bylaw, and if they are going to address matters of noise, nuisance, and property maintenance, there must be a bylaw to deal with those matters. And of course, Part 7 and other areas of the MGA list a number of other discretionary spheres of jurisdiction that council can act through bylaw. As a refresher, resolutions are formal records of decisions voted on by council, and the standard template for recording resolutions would include a record of the mover and the seconder, a whereas clause that includes relevant background related to the decision, a be it resolved clause that describes the direction or action taken by council, and finally, a record of whether the motion was carried or not, and the number of votes in favor and against. As an overview for the bylaw process, we have three separate phases outlined here. One would be drafting and due diligence, where council and CAO review the enacting language and pinpoint the authority that is in effect for the particular action. Make sure the language is clear and enforceable, and once the bylaws are drafted, it would be appropriate to seek legal advice. Next, council will read and adopt the bylaw itself, and this includes a first and second reading, a formal adoption by resolution of council, and after the bylaw is adopted, there are opportunities to amend or repeal the bylaw. Municipalities must keep an indexed register of all bylaws passed, and has the authority or power to hire an enforcement officer to enforce bylaws. Note here that all bylaws are amended or repealed by another bylaw. We'll talk about this further later on. Bylaws will be read twice at meetings of council that are held on different days. After the bylaw is read a second time, it is formally adopted by a resolution of council, and it is signed by the mayor and CAO and sealed with the corporate seal of the municipality. During regular council meetings, when bylaws are tabled for reading, the presentation of the bylaw can simply be the title of the bylaw and a short description of the contents of the bylaw if a draft bylaw is provided to the public to read in advance of or during the meeting. As the CAO, you will be called upon to help with drafting bylaws and performing due diligence to make sure the bylaw does not conflict with other laws and regulations, and due diligence around ensuring the bylaw is meeting the desires and needs of the community. Templates are available for most of the mandatory bylaws now, and those are available online through Municipal Affairs. If there are mandatory bylaws that your municipality has not yet enacted, it would be good to set aside some time to review your current documents and compare those to the current needs of the municipality and the requirements under the MGA. The templates that are available might be more robust than suit the needs of your municipality. So don't be afraid to cut out provisions or add additional provisions in order to meet the needs of your community, the desires of council, and your residents. Make sure, again, that you are willing to enforce the bylaws that are enacted as a municipal council. From a practical drafting perspective, you can do things like use the track changes function in Microsoft Word or other collaborative means to work with council members on drafting new bylaws. And then once the bylaws are prepared, it would be a good idea to reach out to a municipal lawyer or another professional for a second set of eyes on those documents. The bylaws must be approved by a majority of the council members that are in attendance at a meeting and entitled to vote. They're formally adopted by a resolution, and most sample bylaws will include language for the first and second readings, as well as the final resolution for adoption. Here you'll see an example of that language in a bylaw template from Municipal Affairs. It is the CAO's role to ensure that there is an indexed register containing certified copies of the bylaws of the municipality. Certified copies are copies that the CAO swears are true and accurate, and the original copies, of course, have the original signature of the CAO and the mayor and are sealed with the municipality's corporate seal. In terms of transparency and engagement with the public, bylaws should be readily available for the public to review, and all bylaws must be filed with the minister responsible for municipal affairs. There is now an online filing tool that municipalities can use. Consolidated versions of bylaws are bylaws that have been amended or repealed by another bylaw, but the administrator consolidates the versions into one up-to-date version for ease of reference. This is not the official bylaw, as the official bylaws are the original bylaw and all the bylaws for amendment and repeal that have been signed and sealed. Municipalities have the authority to regulate behavior and actions to protect public interest and other matters within their various areas of jurisdiction. So that means that municipalities do have the authority to enforce the bylaws that they create, and to do so, they may appoint a bylaw enforcement officer. Any enforcement of bylaws must be done through a municipal bylaw. Municipalities may, by bylaw, authorize a municipal offense ticket to be issued for a wide range of offenses, and the authority for this type of activity is found at Section 227 of the MGA. Various remedies for breach of bylaws can be fines, injunctions, or orders to comply with bylaws, and those would typically be sought through an application to the Supreme Court of PEI. There are other instances where the municipality simply issues an offense ticket for a contravention of a bylaw, but again, the authority to issue an offense ticket is limited, and the situations in which it is permitted are outlined in Section 226 and 227 of the MGA.